court's rulings or attempting to provoke a mistrial in this matter. He knows he can't go into this, and he's asking the questions. I asked the court to strongly admonish him, and the next time it happens, I'll be asking for a mistrial with prejudice. He's an experienced attorney, and he knows better.
The subject of a motion, I'm well aware of that, and the court left the door open.
For me, not for you.
My understanding of
You should have come and asked. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So I don't know what you're up to.
and protect property.
No, he wasn't.
Your Honor, with all due respect,
I'm not going to rehash the motion. That's absolutely untrue. No. Your argument's of record. My comments are of record, and why I ruled as I did is of record. There's nothing that I heard in this trial to suggest anything's changed. Even if you're correct in your assumption that you know more than I did at the time, you should have come to the court and say, I want to go into this. Why you would think that you could go into it without any advance notice to the court, I don't understand that. And as the defense is pointing out, you're an experienced trial lawyer, and this should not have been gone into.
he said I was joking when I said that to the guy in the yellow pants, but he's acknowledged that he told the person in the yellow pants, yeah, you're right. I did point a gun at you when you were sitting on a car. Attempting to impeach him now with the prior August 10th incident, 15 days prior, involving the same gun, where he is threatening to use that gun to protect property.
He didn't have the gun with him.
Your Honor, he is saying he wished he did so he could shoot people.
You know, there's a lot of difference between commenting about something when you haven't got a gun and threatening someone when you do.
You know, it's interesting. His state of mind, his intent, his belief as to self-defense is the core of this case. That was the basis for my motion. You were stricken on his statements.
I'm going to interrupt you now because you're talking about his beliefs. I think that's what they call
his statements.
Where they've opened the door, the one time when they're going into Mr. Rosenbaum's prior reason he doesn't like guns, and I said something, I whispered in Mr. Krause's ear, it's because of the prior convictions. Please stop, and he did. He knows if you're going to go into something that's been excluded in a pretrial order, you better ask the court, you better get permission. This is ridiculous.
It wasn't excluded, Your Honor.
You know why it was excluded in the first place? Because it was propensity evidence. Talking about his attitudes, his attitude is he wants to shoot people. Now, I've admitted that kind of evidence in other trials when it's been appropriate. I didn't admit it in this case because, to me, what I've heard in this trial, and by the way, Mr. Richards absolutely correctly points out that just hours ago, I said I had heard nothing in this trial to change any of my rulings. So why?
Testimony, Your Honor.
Pardon me?
That was before the defense testimony.
Don't get brazen with me. You knew very well. You know very well that an attorney can't go into these types of areas when the judge has already ruled without asking outside the presence of the jury to do so. So don't give me that. That's number one. Number two, this is propensity evidence. I said at the time that I made my ruling, and I'll repeat again now for you, I see no similarity between talking about wishing you had your AR gun, which you don't have, so that you could fire rounds at these thought to be shoplifters, and the incidents in these cases, which are not, there's nothing in your case that suggests the defendant was lying in wait to shoot at somebody or reflecting upon the shooting for a vast amount of time. Every one of the incidents involves matters that involve seconds in time. So I commented at the time, I don't see the similarity, and I don't see the similarity now. If it's not similar, that's the crime. The prior act has to bear the signature of the accused, or it has to be so similar as to suggest it's a common plan or something like that. You have an incident where he's making comments about some alleged shoplifters versus crimes that involve instantaneous actions, whether premeditated murder or whether self-defense. That's for the jury to decide. But I don't see the similarity. I said it couldn't come in, and it isn't coming in, no matter what you think. Number two, I have to be concerned that with what Mr. Richards has said about the progress of the trial, or over the line, close to or over the line on commenting on the defendant's pretrial silence, which is a well-known rule. I'm astonished that that would have been an issue. So I don't want to have another issue as long as this case continues. Is that clear?
It is.
Thank you. Ask the jury to come back in, please.